All right, let's get this going. We got a number of things to do today, and I'm just hoping to just run right through them. We're going to do a couple of different recordings here. We have my motion, then we're going to do theirs, the decision, and we'll see what other time that we have. All right, it is December, let's say 23rd. We do bifurcated Christmases. Besides whatever other holidays we share, for example, we always did Hanukkah and Christmas when I was a kid. Those are the two switch-offs and compromises and everything. And with my family here, that's with my birth family. With my family here, we have Danish Christmas and American Christmas. American Christmas is mostly 2 meals on the 25th and a lot of presents. Danish Christmas is conversely a huge meal, a lot of work, and a whole bunch of traditions leading up to like midnight, and then presents, and then we sort of redo it all over again. It's a thing. It is a marathon. And this is just one of those years where everything falls together. So I am resting, recuperating, and getting ready to go. 7 o'clock in the morning here in Wisconsin. It is not quite pitch black, but it's dark. Happy solstice to everybody. And I guess we'll have to turn down all the fats here to pass this message on. This dark day always reminds me, it was last year, it was -20 here. That's in the old Fahrenheit scale. That's cold. Wherever you live, it's water will freeze in like 10 minutes kind of thing. And I lost Big Boy, the goat, and his little guy, his little buddy. That was not fun, and it just always is my big reminder of we got a lot of work to do. We all got a lot of work to do. So let's get it done. Now, yeah, it's amazing. Anniversaries are amazing right there. Okay. So, setting the stage and refocusing again, we had been talking about the Sue Novak case. We have been in the middle of the judge's discussion on why she's not biased. Okay? We did the essay. I'm not biased because. Okay. In real time, in the middle of us discussing that, the issue came up of deposing Secretaries Carr and Petchacek in another case because they were the bad actors in those cases. This case in particular. Carr, of course, is the ultimate decision maker, and Petchacek being the supervisor of internal affairs and in his cabinet on his leadership team. They're the decision makers. They're the ones making the decision. So we'll see basically what happened. There's a federal case out there that says that secretaries and high government officials, you can't be dragged into depositions. Okay. By the way, it's different for hearings, but you can't be dragged into depositions. Okay. So without a good reason that you've got the burden to establish ahead of time. Okay. You can't just call them in, use deposition, and bring them in as leverage. Fine. Okay. So we basically have the burden here. That's what this is all about showing that there's a good reason to get Carr and Petchacek. Okay. Now, they basically also allege that this was harassment, but we're not going to go into that. This is also before the same judge who told us to withdraw from the case and then gave us a form. And then when we responded and saying that wasn't okay, immediately told us that because we didn't withdraw, it undermines our argument for that we needed Carr at Petchacek. So we'll get into that too. We've got that document, and I'm sure we'll read it. But this is that judge. This is that controversy. Again, he also took extreme umbrage with at any time he is referred to, Secretary Petchacek is referred to as his supervisor. So I just want to be clear on that. Extreme umbrage. And maybe we should just get into that so we can set that scene. I'll pull up those emails. If you'll excuse me, I'll be right back with you. All right there. Thank you. So if we'll just remember here, I got a letter from the judge saying, if you're so concerned with the notion of a conflict of interest, that's in quotation marks, regarding Amy Petracek being the acting secretary of the Department of Workforce Development, the DWD, the umbrella organization, which includes the Equal Rights Division. And we read this out and we went to the word chart, but we're just going to keep going down because there's a part here that I want to emphasize. Then dismiss this case and any other case for which you perceive a problem and take it to the EEOC. I am attaching a withdrawal form for you to fill out and sign and return, okay? Then he goes on here and it says, this is why, remember, I didn't get to file a response because supposedly I gave up that right to respond because I didn't respond within 24 hours. So this is him responding to that point that I'd made. As previously noted, I have been trying to resolve these issues as quickly as possible, given the approaching discovery deadline of December 18th, 2023. In addition, we are approaching a period when many people are away from the holidays. Time is of the essence. You should not need to be prompted to respond to a legal filing involving your client's case. Additionally, that just sounds like Stephanie Brown to me. Additionally, as previously noted, you had over 2 years to conduct discovery and are addressing these issues at literally the last minute. Okay, we'll get into how true or accurate that is later on. But we'll go on. And this is from John Gelhards. He's an administrative law judge working out of Milwaukee. Okay. So, I respond as follows. Judge Gelhards, while there is much in what you write that may require a substantive response, such a response requires care and consideration, so I will reserve that for another time. I will point out that your appeals to the holidays are not well received, this being the last night of Hanukkah. I spent much of this holiday, albeit not the Western Christian one, responding to motions filed by the respondent and Secretary Petracek. I mentioned this on Monday when I objected to your less than 24-hour deadline. Shalom, Ben Hitchcock Criss. And I don't go around, by the way, waiving any religious affiliation, any holidays that I may or may not attend, or anything else. And certainly don't go around putting shalom on emails unless there's a reason to put a point on it. So at least there's a point. And this email from this judge is coming from the Equal Rights Division, okay? So he's telling us that I should have known that the holidays were coming up and that some people, and we're going to find out which people he's talking about, were concerned about the holidays, and that therefore I should have altered my plans to meet those Western Christian holiday demands. And that's sort of like you're not being Wisconsin nice kind of dig. That's part of what that is. But that's the point is, I think, that when somebody's employed by the Equal Rights Division, you don't expect them to prioritize one set of holidays over the other. That's my point. We'll see what happens. You know, by the way, when I have to sit there and listen to judges like read out their responses and I have to wait till the end and I have no patience and they say like, we'll see what happens or something like that, I do find that to be, okay. All right. Now, here we go. Attorney Cross, I appreciate your sharing your religious affiliation with all of us. Then this, by the way, is written on Sunday afternoon. So, and let's just get the timing here right. So he sends out this thing. And by the way, he copies Jennifer Wackenhauser on this email, all these emails, which is Secretary Petracek's personal attorney. Personal meaning cabinet attorney. Okay, so he sends this out on 12:29 p.m. on Friday. I respond at 2 o'clock on Friday. Then on Sunday at 12:30 p.m., he writes, I appreciate your sharing your religious affiliation with all of us. The comment about people being away for the holidays was a reference to the two individuals for whom you seek depositions, which, if you recall, has been the focus of the communications between the parties of late. So I guess we can go back and look at that, whether or not there was any actual mention, whether or not, then we can look at whether that was evidence, and then we can look at whether or not there's some kind of, because the implication of that is that there's a secret rule that everybody should know, which is that if Secretary Carr, Petchacek want to go somewhere for the holidays, which, I don't believe they ever told me, but apparently this guy knows that they have plans for the holidays. I wonder how he got that information. Could it possibly be because, that's what I would, at the very least, we would need to see somewhere in the record where some representative of Petchacek and Carr, by the way, and it has to be and, says that they have holiday plans. I, by the way, see them saying that they have plans on that Friday because they have to be at a cabinet meeting. That I saw, plenty of that. But holiday plans, I didn't see that. But again, I'm not clear anywhere where it says their holiday plans are a item of consideration here under the law. And we'll also note how it goes from, let's just read that here. We are approaching a period when many people are away from the holidays. Time is of the essence. And this goes back to the previous sentence that said, the attorney for Ms. Petchacek filed a motion to quash the subpoena, okay, which was improperly served. Didn't get a chance to respond to that like we want to, okay? You could have responded, but you didn't. As previously noted, I had been trying to resolve these issues as quickly as possible given the approaching discovery deadline of December 18th. In addition, we are approaching a period when many people, and just so I can rephrase that, my boss, with apparently which I have knowledge that she's got holiday plans, are away from the holidays. Time is of the essence. So that's that is that. All right. So then we'll keep going. This is again from the judge. I did not find a signed request to withdraw complaint form attached to your email asking to send the case to the EOC. This seriously undercuts the complainant's contention of a legitimate conflict of interest. I will go forward with a decision on the motion for a protective order. Now, based on that statement there, how do you think that the motion for the protective order is going to go? Any thoughts? All right. I just on that subject here, because we do have the log, but apparently I printed it out in minuscule font here. But this is what's known as a case log. They've got this sheet here that they've got to write down all the events that have happened. Here's how the judge characterizes this emails. ALJ emails Attorney Cross, request to withdraw form to fill out in order to transfer his case to EEOC in light of his claims of conflict of interest. Email from Attorney Cross indicating that he is Jewish and all recent procedural matters have occurred during Hanukkah. In response to ALJ's line that the people might not be available over the holidays. I think that says more than his original letter says. Email from ALJ indicating that away for the holidays referred to the two individuals complainant was seeking to depose, the lack of request to withdrawal form undercuts claim of conflict of interest. There you go. Did anybody feel like that was a I mean, I guess we don't even need to go into whether or not it was a threat because the behavior was immediately followed up with action. Immediately. I mean, there wasn't even a chance to act. There was a space of no business days between the two. But I do think that we have to look on the statement there, and I guess we need to read it again. I did not find a signed request to withdraw complaint form attached to your email asking to send this case to the EOC. This seriously undercuts the complainant's contention of a legitimate conflict of interest. I will go forward with the decision on the motion for a protective order. All right. So let's just look at that for 1 second if we can. Because to say that, I guess there's two steps to that, and we're going to go to the second one there. The word prejudice is really and Judas, meaning but it's judging, prejudging. You're gonna get my terrible Latin pronunciation, and we're not gonna deal with that. So, but that's the whole concept. You're prejudging. Remember, this is a judge, and remember they're supposed to listen to the evidence and then make a decision based on the law and the evidence, not prejudge. That's the whole concept of prejudice. Okay, we do kind of think it's like a harm or a negative. It is a negative, but one of the reasons why it's a negative is because it's a predecision. It's a negative predecision. I mean, I assume there could be positive prejudice too, but we just don't think of it like that. But legally speaking, that's what we're going for. Why am I still wearing these cans? I don't know. Okay. I should just read out what I wrote. All right. So, the second thing is this concept here of the fact that we haven't immediately withdrawn when instructed to do so. And what does he say in here? Okay. And I'm sorry, you got to look at my forehead. That must have been fun for you. But I'm still just sitting here baffled at this concept of you have to withdraw your case because you're alleging that there's a conflict of interest. I think that's the bottom line concept of what we're trying to get at. How does that possibly come into play? Now, my first thought was maybe this case could be transferred to another judge. Maybe that judge could stop being a judge. Maybe Secretary Petchacek could stop being the secretary. That those were conditional things, those were privileges. And in contradistinction, my client is a complainant who is exercising her right to file an equal rights complaint to the division that's charged with enforcing the equal rights law in the state of Wisconsin. So just on that sort of balancing there, I get it, somebody's job, it's somebody's career, I get that. I mean, those are all perfectly legitimate reasons, but we always tell people, well, you can just get another job. We'll just go do something else. I mean, what's the big deal? It didn't work out there, just get another job. Well, it's not work. I mean, I feel like that's not it. It's not a right to employment. We don't say that word for a reason. The law doesn't reflect that they have a right to those jobs. For example, the secretary is at the pleasure of the governor. She doesn't have a right. She couldn't sue if the governor said you're out. That's it. Okay? Now, if they just throw Joanne, the complainant, out, they will have a problem because they will have violated her rights. Okay, just in contradistinction here, we're talking about one has a right to do something, the other is not a right. So we're going to go there. Debbie Keither pointed out, well, why don't they just act like adults, the secretaries, sit for the deposition and answer the questions? That might work too. And I hadn't thought of that. So that's why always spread your ideas around. Did you, by the way, take from my statement here that says your appeal to the holidays are not well received, this being the last night of Hanukkah? I spent much of this holiday, albeit not the Western Christian one, responding to motions filed by the respondent and Secretary Petchacek. Just for example, okay, on the subject of inferences, it's possible to infer that that's what I mean. It's also possible to infer that, for example, my dad invited me to a Hanukkah celebration and I had to postpone that or not go with my children, for example. I don't know, you could think of some other things. Because I stayed and wrote what we're going to read, just for example. Okay? Now, what you might take from that, given additional information, and what others might take from that, who knows? Okay? But given this statement here, I point out that your appeal to the holidays are not well received, this being the last night of Hanukkah. I spent much of this holiday, albeit not the Western Christian one, responding to motions filed by the respondent and Secretary Petchacek. Okay? And here's what the judge, whose job it is to judge and make inferences and so forth, took from that statement and wrote down in a government document. Email from Attorney Cross indicating that he is Jewish. That doesn't make me feel, by the way, one hates to be a character in one's own play, but one feels that one is not getting respect for equal rights. And by the way, religion and creed are pillars of equal rights that this judge is paid to uphold. Just keep that in mind. He's not like, he doesn't go do other things. He's not sometimes a criminal judge, sometimes a whatever judge. He's focused on his number one focus in life is to hear and to make decisions on equal rights. And that's what he took from that statement. I just want to be clear on that. We've got a great snapshot there, I think. Now we can go up. It took me a while to respond. I think some days because I had to get the old chin going. I need one of those, those like rubber ball things that people put. There's some amusing advertisements on YouTube this time of year. All right. Here we go. Judge Gelhards. The department certified the complainant's complaint to a hearing on the merits. Months ago, the complainant asked Secretary Petchacek for an administrative law judge from another department to avoid the conflict of interest. To suggest that the complainant's only remedy for a conflict of interest between the secretary and her subordinate, attached their chart there, we can see the 4 hops, is to lose her right, well, like that, to a ERD hearing before an unbiased hearing examiner denies the complainant her statutory and constitutional rights that follow the certification to hearing. Administrative law judges are not only presumed to be unbiased, because he quoted that rule here, but they're also required to be unbiased. We believe that the state of Wisconsin will not permit a biased decision. Okay. There's a little scene setting for you. We're at 26 minutes. I'm going to stop here. We'll just keep rolling along. Maybe I'll change my outfit. I don't know. Should we even do closing music for what the heck? I don't know. I mean, hey. I changed all the button sliders, everything. But here's what I want to underscore with this is, in my mind, this is really the I think lack of self-awareness, I think, is what is most shocking to me here than anything else. Both in terms of the conflict of interest, so that sort of lack of awareness there about that conflict. And I think most any professional who would be in such a situation would take positive steps to get themselves out of that situation, or put on the record that they had taken positive steps to get out of that situation. I don't think it's enough to just say that somebody who is the head of my department, whose name is on this decision, who appointed my boss and their boss, does not have a pecuniary control over my life. We just don't. And whether or not it's true, whether she did that, we don't have to. It's the risk, a serious risk of actual bias. And I think there's no question that we're past risk there. Okay. So many people don't even want to get to serious risk. Sometimes they're at any risk, or a little risk, or risk, when they get to, a substantial risk of actual. I mean, it's like, come on. I think that means a judge and the Supreme Court of Wisconsin need to get involved. Many people wouldn't want to be there. Okay? Many people wouldn't want to have statements put in writing about their mere surmise, sir, on an attorney's religious affiliation, and certainly not put it in writing. That to me is shocking. And if he was on a judge in charge of religious identification, then that would be totally appropriate comment. If he was in the morality police or some other thing like that. But when he's in the equal rights division, that does not seem to me to be a comment or an action that promotes equal rights. I think we got to be clear on that. That's that was, as they say, not cool. Um, you know, I gotta say here, there's a lot of things in this world that we resent as kids, and I surely had my share of them. But I always felt that this approach to multiculturalism that we had there, which was make everybody sing a song, a holiday song, and we'll have one Kwanzaa song and one Jewish song and 5 Christmas songs and one various ethnic thing, and maybe we'll say something from Africa that vaguely means peace, but really nobody knows, um, like that. I always found that to be kind of oppressive towards everybody and not really inclusive at all. I have to say. Um, but to me also it's because they're it's the government making children do these things that is always sort of troubling, and they're saying, well, it kind of cancels itself out because we're making you sing a Kwanzaa song, but we're also making you sing a Christian song or whatever. Okay. That, to be clear, it's just it's the being made to do that is the thing that I think is, and this is what this channel is all about, is government action, and to have the government say what they put in writing on a public record their surmise as to your religion, that's troubling. I'm troubled. I'm gonna say that Ben Hitchcock Cross is troubled by that behavior. Um, and here we are. I'm talking about me. I fell into my own trap here. The biggest issue really is the statement that in order to alleviate, and we get this from bosses all the time, that it's your job to fix my problem. Well, not when I have a right, it's not. No, no, it's not. That's your problem. It's not my problem to make your job easier. It's not my problem to make it so that you don't have a conflict. It's not my problem to ensure that the hearing is held in an unbiased fashion. It's not my problem. The state of Wisconsin has promised that it would hold hearings, and the Constitution of the United States and the state of Wisconsin ensure that when they promise to hold hearings, they must be unbiased. So when one has a right to something, one doesn't have to say pretty please. One doesn't. And one gets statements like, you need to withdraw. Oh, the fact that you didn't alleviate me of this conflict of interest and that you've accused me of having a conflict of interest, which, I mean, I don't know that we accused. It's just the fact that she's your boss. Just look at the chart. And it's a fact that you've given her, without allowing us to have a chance to respond, what she asked for. Those are facts. So, yeah, there's just some critiques there. All right, stick with us. We'll keep you informed. Ba-do, 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 do, 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 ba-do, do, 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 do. Have it.